vertical reservation and accordingly, this is the first part. And accordingly, the second part the state has not complied with. Please see the second part also. Please see the second part also. And notwithstanding anything contained in 917 so and so and elsewhere in the Act, providing reservation for scheduled seats and offices to be reserved for backward classes shall be so determined. Duly keeping only one submission, the requirement of reservation in Geo 41, my lords. In item 42, my lords are saying. Yes, my lord. Please see the second page of Geo 41, my lords. 41. The table, it's eye-opening because in so far as ST-SC population are concerned, they take the 2011 census. But in so far as BC populations are concerned, they are taking this the survey which has been done in 2024. Why? My lords, if the section has to be given full effect too, which they are bound to do, shouldn't they have looked at the SC-ST population by undertaking the same examination for BCs, which they have taken up in 24? They should then come to a conclusion that the proportionate increase of SC-STs are not as much as BCs, and therefore we are making provision only for BCs. Argument's sake, if they do this exercise, they come to know that SC-ST population is very low. BC population has increased. They are not being properly represented in public life. We are giving effect to them. Have they done that? They have not done that. They have only looked at the population figures of BCs in 2024 as opposed to ST-STs in 2011. This violates the Act, my lords. And one more submission is that it violates the Act. The state was saying on the last occasion, on 27th, my lord, they said that Justice Pardiwala's opinion in State of Tamil Nadu decision has said if it is kept for the assent of the governor for a period of 1 month, it constitutes consent. I'll just put a question to myself. With great respect to the state, that is not what the Honorable Supreme Court has said in state judgment. Well, please take this copy. Well, this is important because on 31st of August, I'm sorry we are taking your lordships to this voluminous documents, but lordship will notice the State of Tamil Nadu versus Governor of Tamil Nadu. The direction insofar as the president is concerned has been given back by the president to the Supreme Court under advisory jurisdiction of can you do that. But please notice para 250.
Yes.
Please see page 2, para 250. At page 212, the bottom portion has the page numberings. What I'm only trying to say is that the Geo has only recorded the fact that it is a bill. Unless it receives the governor's assent, it is not an amended situation. What the Supreme Court is saying, it's not like a deemed approval, my lords. Please see. Keeping in mind my lords are saying para 250. Keeping in mind the constitutional significance of Article 200 and the role it plays in the federal polity of the country, the following timelines are being prescribed. Failure to comply with these timelines would make the inaction of the governor subject to review, not deemed approval, subject to review by the courts. In case of either withholding of assent or reservation of the bill for the consideration of the president, upon the aid and advice of the State Council of Ministers, the governor is expected. Please notice that word. It's not a direction. It is an expectation. My lords, they have stretched 142 article to its limits. And 142 article has been, so they're very careful as to how they are referring to their equals in the executive side, which is the governor or the president. The governor is expected to take such an action forthwith subject to a maximum period of 1 month. He has to take action. Now see what happens. In case of withholding of assent, contrary to the advice of the State Council of Ministers, the governor must return the bill together with a message within a maximum period of 3 months. So he has to take action forthwith within a period of 1 month. If he disagrees, he must give back the bill within a period of 3 months. These timelines are important if we are to take this assumed consent or whatever. In case of reservation of bills for the consideration of the president, contrary to the advice of the state council, the governor shall make such reservation within a maximum period of 3 months. So you should decide within 1 month. If you don't decide within 3 months, you must give it back to the council of ministers. And then, my lord, in case of presentation of bill after reconsideration, in accordance with the first proviso, the governor must grant assent. Now, please notice that word grant assent forthwith, subject to a maximum period of 1 month. But you can't read this sentence in isolation, independent of the earlier provisions, my lords, or earlier direction. So what it says is, you decide in 1 month. If you don't decide, give it back in the next 3 months. And if it comes back to you for after reconsideration of your council, if it comes back to you, then within 1 month, if you don't decide, then it is assumed assent. That exercise has not taken place at all. As my learned friend has submitted, on 31st of August, the legislature has passed a bill. They have kept it for the assent of the governor. We are still in the first August, September. 1 month has passed by. Now the second part of this provision, that within 3 months you must give it back to your council of ministers, that has come into effect now. After that is over, they give back the bill back to you. Then you must decide within a period of 1 month. If you don't, then there is assumed consent. But what the state appears to be arguing is, because in 1 month you didn't decide, therefore there is assumed consent. Now that is also an argument in futility. Because the law declared by your lordships in the Honorable Supreme Court has said 50% cannot be breached.
All that.
Also, please also notice, my lords, just to conclude, my lords, in item 42, in item 202, item 42. In item 42, just one last submission, my lords, I'll just bet. In 2018, 34% reservation was introduced by the state. This came to be challenged before your lordships. In an interim order, your lordships stayed it. They said
was shown. That
yes,
was shown.
that was not shown, my lords. Please see page 202. Only for a moment, please see page 202. I'll conclude, my lords, with great respect. I think I've gone into your lordship's lunch hour.
So great reservation is required for minor also.
Just see in item 42, just one paragraph I'll show. If your lordship were to see in item 40,
Please read it.
shall I read it? Yes, madam. This is in page 202. Is item number 42, my lords. Page 202. This is my lords, WP 25651 of 18. The fundamental issue, and this may be revelatory, my lords, when your lordships are considering whether to give or not to give interim relief. This interim order has been given 6 months before the enactment of 285 Cap A. It was given in the month of July. 285 Cap A came into the statute book in December of 18. The interim order is given in July of 18. So they're relying only on Supreme Court decisions without going into the thicket of section 285 Cap A. Now, please see the fundamental issue. That's why I wanted your lordships to kindly see it, my lord. The fundamental issue raised in this writ petition is regarding the reservation of seats in Gram Panchayats and other local bodies, which we hereinafter refer to as local self-government. The fundamental contention of the petitioner is that the reservation is in excess of 50%, which could not have been made in the light of the Constitution Bench decision. Only one decision the petitioner relies on, Krishnamurthy, and says 50% breach violates Krishnamurthy, please interfere. That's all he says. That's all the court also says now. Please see, in the light of Constitution Bench decision of the Apex Court in K. Krishnamurthy versus Union of India, the learned counsel for the petitioner making reference to the said precedent argued the position that it amounts to law by the Apex Court. Now, please notice the operative portion, my lord, and this is revelatory. I'll just read that one paragraph and leave it, my lord. However, of the view that the law laid down by the Apex Court is clear and categorical to the effect that the upper ceiling of 50% vertical reservation in favor of SC, ST, OBCs should not be breached in the interest of scheduled tribes should not be breached in the context of local self-government. Exception can only be made to safeguard the interest of scheduled tribes that your lordships have seen. In the matter of the representation in panchayats located in the scheduled areas, this is one of the specific enumeration conclusions rendered by the Constitution bench after stating to the said effect in paragraph 64. So your lordships are referring to a paragraph and giving an interim order. This was before the act came into being. Paragraph 64 of page 227 of the judgment in K. Krishnamurthy, wherein the apex court had clearly taken the view that there cannot be any vertical reservation in excess of what has been noted above, that is over 50%. It has also to be noted that K. Krishnamurthy was decided making specific reference to the Constitution so-and-so amendment. Considering the submission of the learned GP on the basis of, this is the same thing they argued. The OBC population of the state has increased, we need to give them more reservation. My lords, OBC population, we are of the view that the only exception granted by the apex court through the directions in K. Krishnamurthy is only as regards STs and SCs. So the court is saying the only allowance which we can make to the state is with regard to SCs and STs when it goes above 50%, not to OBCs. Therefore, we do not find our way to accept the submission of the learned G. For the aforesaid reason, there shall be interim order that the upper ceiling limit of vertical reservation in favor of SC, STs and OBCs should not be breached in the context of local self-government in the state of Telangana, subject of course to the exception that safeguards could be made to protect the interests of scheduled tribes in the matter of representation in panchayat located in scheduled areas. So this interlocutory order is issued without prejudice. Against this order, the state goes in appeal to the Honorable Supreme Court, and then the SLP is withdrawn at page 205.
Very well.
So all I'm submitting, my lords, it's still the law of the land.
Hear the other
May I
side
please-
after
may I
lunch.
please,
No,
my lord?
I
My lord,
wish
may
to-
I please, my lord? My lord, this is with reference to this matter, my lord, please me a moment.
We have heard this at the interim stage only. We'll hear the other side.
Lord, I wish to add for 10 minutes, 5 minutes, I'll take up. I'll be supporting this.
My lord,
And I'll
my
not
lord,
repeat
may
what
kindly
they have said.
permit-
Allow us to have the lunch.
I'm very sorry. I'm sorry again.